What happens when you say your friends that you know something? They will ask you to prove it, right? It is a common thing, and law is not something different. Law also goes in a similar line. Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Evidence Act, we were discussing chapter 7, which is all about burden of proof, covered between section 101 to 114A. Now, this is my fourth video in this series, and here I am going to cover three important sections starting from section 106 to 108. And when you try to read the legal provision under these three sections, the meaning is almost like when you know something, prove it. Now, these are not legal terms, but when you try to read the inner meaning of these three sections, it is almost like if you know it, prove it. Now that's how I see these three sections. I have just two slides and not taking much of your time. Let's get into the first slide. As I said, we are going to discuss three important sections here. The first one, section 106, discusses about burden of proving fact, especially within knowledge. And the provision says when any fact is especially within the knowledge of a person or any person, the burden of proving that fact is upon him. Now, this is an easy provision, but to understand this, we can take the help of illustration B. Now, here is a person on whom the allegation is he has traveled in a particular train without a valid ticket. Now, who has to prove it? The person who has traveled should prove it by saying that he had a valid ticket. Now, just by saying it is not sufficient, he has to show the ticket. Now, no one else in the world would know where exactly he has kept the ticket. He is the one who knows whether it is in the purse or in his shirt pocket or wheresoever. Now, the person who is saying that he has traveled in that particular train has the burden to prove that he has traveled with a valid ticket. That's what we need to understand when it comes to section 106. Section 107 discusses about burden of proving death of person known to have been alive within 30 years. Now the provision says when the question is whether a man is alive or dead and it is shown that he was alive within 30 years, the burden of proving that he is dead is on the person who affirms it. Like for example, we are in 2020 and we know Mr. X was alive in 2010, but after that we don't know whether he is alive or not. 2010 comes within the last 30 years of 2020, like 1990 to 2020 becomes 30 years, and we know he was alive at 2010. Now, if someone says that no, X is already dead, in that case, the person who is saying that X is already dead has the burden to prove to the court that X is dead. Now, that's what section 107 discusses about, and here the time frame that we need to keep in our mind is about a person in last 30 years. Even in 1991, if X was alive, and if someone is saying that in 2020 he is dead, the person who is saying that X is dead has the burden to prove to the court that how exactly he is claiming that. That burden of proof is on that particular person. That's about section 107. While section 107 is about death of a person, section 108 is a different angle. Here it discusses about burden of proving that person is alive who has not been heard of for 7 years. And the provision says provided that when the question is whether a man is alive or dead and it is proved that he has not been heard for 7 years by those who would naturally have heard of him if he had been alive, the burden of proving that he is alive is shifted to the person who affirms it. Now, nobody has heard about Mr. X for last 7 years, but someone is saying that no, X is still alive. In that case, the person who is saying that X is still alive has the burden to prove to the court on what basis he is claiming the same. That is very important. When we say the person is not being heard, it is about the members who are connected to him, his family, his friends, etc. No one have heard about him in last 7 years and nobody is not sure whether he is alive or dead. But a person is saying in the court that no, X is alive. In that case, the person who is claiming that has the burden to prove to the court that X is alive. That's about section 108. In a nutshell, I have tried to bring all these three sections in a simple chart. The first one is, if you know a fact, you have to prove it. That is as per section 106. And the second one is, if you know someone is dead, the person about whom somebody or the other have heard that he was alive in any of the last 30 years, but you are saying to the court that he is dead. In that case, you have to prove it. And the last section, that is section 108, if you know someone is alive who has not been heard in last 7 years, if you are saying that such person is alive, you have to prove it. That's all about section 106, 7 and 8. Now let's move to few important case laws. The first case law that I am discussing for section 106, which is on the burden of proving fact, especially within the knowledge, is Ram Gulam Chaudhary versus State of Bihar. Before even getting into this case law, one should know that in a criminal case, it is always the duty of the prosecution to prove that accused has committed the crime. But here what happens, the prosecution has proved that a particular person was taken by accused, and before taking, the accused said that the same person should be killed. Now prosecution has proved that the person has said that he is still alive and should be killed. Now this is being told by accused and prosecution has proved till here. Now after that what happened, prosecution doesn't know because the accused has taken that person away. Now here the burden of proving what happened after that lies on the accused because he is the only person who has the knowledge that what happened after that. So here the burden to prove shifts upon the accused, which is what discussed in this particular case law. The second section that we discussed was section 107, which is on burden of proving death of person known to have been alive within 30 years. The case law that we are discussing here is Surjit Kaur versus Jujar Singh, where there was one Mr. Sardul Singh and a person was claiming that he was dead on May 24, 1970. But there was an witness who said that Sardul Singh was alive during 1960. Here, whoever is claiming that Sardul Singh dead on May 24, 1970 has the burden to prove that he is dead on that date because within the last 30 years of such person, somebody has heard about him. Now 1960 to 1970 is just 10 years. Somebody has heard during 1960 about Sardul Singh that he was alive. In that case, whoever is claiming that he is dead now has the burden to prove. That is about section 107. The last section that we discussed was section 108, which is on burden of proving that person is alive who has not been heard of for 7 years. The case law that we are discussing here is Ramrati Kaur versus Dwarika Prasad, where the Supreme Court held that as Ramruj has not been heard of for more than 7 years after he disappeared from the village, he must be presumed to be dead. And whoever is saying that he was alive need to prove the same. That is what held here. That's about the case law for section 108. Nishan, what's happening there?
I'm doing distraction dance, Papa.
Don't do distraction dance and distract my students.
Okay, with that, I'm concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye-bye.